Hello everyone, my name is Shruthi Naik and I am one of the editors of Daksha's latest book, Justice Frustrated. We at Daksh are very excited to release this latest volume of essays, which looks to shift the traditional narrative of viewing judicial delay as a problem of the courts alone. We believe that understanding the impact of judicial delay is very important in understanding the problem itself. And to do this, in this volume, we go beyond understanding the cost and time spent in attending court hearings to get a more nuanced and deeper understanding of the problem itself and its impact. The contributors to this volume will let you know more about what they have done in the volume and their work on the problem. And please do get a copy of the latest volume of Daksha's book, Justice Frustrated, to know more.
Hello everyone, my name is Manaswini Rao and I'm excited and honored to be a part of Daksha's new book, Justice Frustrated, the Systemic Impact of Delays in Indian Courts. As an economist, understanding the role of courts as one of the key institutions in shaping an economy is critical. Economies run on trust, and effective courts enable economic agents, whether it's individuals or corporations, to trust one another in transactions. In a chapter in this book, I explore the association between the performance of district courts in India and the performance of companies within the court's territorial jurisdiction. So the chapter suggests that there is a wide variation in judicial performance across districts within the same state. The analysis that went into writing this chapter reveals the need for granular data and the need to analyze factors behind these judicial delays. So our conversations surrounding the Indian judiciary needs to expand beyond judicial delays to examine both these factors that cause these delays as well as examine the impact of these delays.
My chapter, which is titled Consequences of Delays in the Trial Process, the Under-Trial Experience, is very obviously about the impact of judicial delays on the lives of under-trial prisoners, particularly those that come from very marginalized sections of society. And a large number of under-trial prisoners, more than 70-80%, do come from these kinds of backgrounds. And the impact that this has on their families, particularly their children who may be left outside while the parent is in prison. The impact that this chapter talks about is more about the impact it has on the social aspects, particularly on the family, in terms of livelihoods, in terms of social stigma, in terms of social exclusion, and in terms of social identities, which leaves a lasting impact on their lives.
In my chapter in Daksha's Justice Frustrated is about land acquisition cases. I have looked at data about relating to land acquisition cases in Karnataka, specifically in the trial court and in the High Court, to see what sort of delays are taking place and what is the impact of such delays on these projects. What is ill explored is how the judicial process sometimes contributes to delays in land acquisition. What these delays result in is the fact that the economy is affected since the land cannot be put to proper use or whatever use that the government had in public interest. Therefore, what this paper does is to look at what are the causes of such delay, how do we identify the causes of such delay, and what can be done about it.
There are different aspects of cases that the chapter focuses on. These are number of hearings, the stages through which a case goes through, the days between each hearings, etc. The chapter analyzes these attributes and measures its impact on the disposal of cases.
This chapter talks about the time series model, which is a way to show the trend regarding the number of cases about to hit the court in the coming years. Now, this piece of information is quite important for the judges and the court industry to take precautionary measures regarding these bulk load of cases they're about to see in the coming years. Like a similar trend can also be generated regarding the amount of pending cases about to see in the coming years, the amount of disposed cases about to go in the coming years. Now, furthermore, this chapter also talks about the life cycle of a case.
In my chapter, I examine the adverse impact of judicial delays on the litigant himself or herself. When a case is pending in the court, it is not just about time or statistics in the judicial system. it has an impact on the life of the litigant. Every case is about rights of a litigant. Therefore, the longer it takes for the court to decide the case, there are adverse impacts on the rights and therefore on the life of a litigant. And these consequences are numerous and have various facets. I examine each of these facets in my chapter.
Cases under the Insolvency and Bankruptcy Code make for a particularly interesting study because the law itself places a huge emphasis on timelines. One of the stated objects of the IBC is timely resolution or liquidation, and timelines are built into each specific step in the resolution or liquidation process. In this chapter, we use data that's based on cases in the last couple of years since the IBC came into effect to assess the extent to which these timelines have actually been adhered to in practice.
The chapter deals with an interesting aspect, that is, which is the aspect of delay and how does it impact society. It has been pointed out that because of lost delays, people are usually slowly but surely losing out their confidence in the judicial system. And that is leading to the citizens resorting to extra-legal methods. This is something which is not to be encouraged. So there are aspects on which some comments have been made. At the same time, the biggest litigant in the state in India, and the state is a party to more than 75% of the cases that are being coming before the courts. And so if the litigation system is better managed by the government at the state level, then the number of cases coming is going to get reduced. And that will considerably reduce the burden on the litigation system. This is one important suggestion that has been given in this chapter as a means for reduction of delay.
The chapter also suggests the remedial measures that could be employed to combat the causes of delays in the justice system, while keeping in mind the steps that have already been taken in the past, their successes and failures, and suggesting a course of action that ought to be taken in the current environment that could alleviate the burden on the judiciary. The measures suggested in the chapter span the entire breadth of societies, so a systemic change can be initiated, from the grassroots level to the highest echelons of the government. This also includes suggestions for the improvement of current systems that are in place, such as alternate dispute resolution, lok adalats, etc.
Why did we decide to study this particular question? Increasing judge strength is a very common recurring suggestion for judicial reforms. Everybody says let's just increase the number of judges. So we want to actually test what increasing judges meant at the judiciary, at the lowest level, the district court level at a particular taluk. And that is what we have done in this chapter.
Our methodology draws on survival analysis, which is a field of statistics that is typically used in medicine and economics and biology to study the duration of a state and the factors which influence it. It's only recently gaining ground in the study of legal cases, but it's a very appropriate methodology given the questions that we are trying to answer. And so we chose to use this survival analysis. Our data set comes from Mysore and Chamarajanagar districts, and it consists of data from cases and hearings in district courts from the period 2000 to 2018.
I think it is important also to state that what we have taken is a very quantitative approach to looking at the problem of impact of increasing judge strength on the justice delivery. It is only looking at pendency, disposal, time taken for disposal or pendency in terms of time. We have not gone into, for example, what it means from an access to justice perspective. Were more people able to approach courts? Or from an outcome perspective, were the judges able to spend more time per case and therefore were they able to give better outcomes to the justice process? So these are questions that can be tackled in further research now that we have got one particular question out of the way.
Human trafficking is the largest organized crime and the third largest illegal trade after drug trafficking and arms smuggling. This paper examines the survivors' confidence on the criminal justice system for a period of 4 years, from 2012 to 16.
One of the significant issues that our survivors of human trafficking face during the legal processes are delays, which includes both investigative as well as judicial delays. Our paper demonstrates on the impact of the significant cost incurred to the survivor who come to court to testify. Our paper not only talks about an inactive criminal justice system, but it also talks about the socio-economic hardships on the victims, which brings in a deep mistrust on the system, leading to very few people who are willing to stand and fight against their injustice.
The chapter which deals with court processes which aid arbitration looks at the impact that delay has in the context of arbitration matters. But this obviously means when arbitration was touted as the remedy for delayed court resolution, we were hoping that arbitration would have easier answers. So how has this really impacted both commercial litigants as well as the society, and the larger judicial system is something that is at focus here.
My co-author Titiksha Mohanty and I have contributed a chapter on adjudication of election petitions and the performance of Indian courts for Daksha's book, Justice Frustrated. Our inspiration on writing this chapter comes from an observation in the 255th report of the Law Commission of India, which rules the unavailability of data on time spent in adjudication of election petitions. Now, we believe that most of the discourse around elections stems around suitability and eligibility of candidates and the conduct of the election process. Our chapter talks about adjudication of election petitions, an aspect that arises after the process of conduct of elections is over. The findings of our analysis gave us important insights, broadly categorized around two aspects. First, we gained a sense of how long high courts have been taking for the trial of election petitions, and how well those time periods sat along with the time limit of 6 months that the RP Act mandates for disposal of election petitions. Secondly, we also got a bird's eye view of the recurring issues which operate as bottlenecks in the expeditious disposal of election petitions. Now, analysis of these issues is very important because the trial of election petitions, unlike disputes between private parties, is inherently important and has political implications as well.
Book chapter, The Effective Hearing in Public Interest Litigations. Ritwika and I, we look at how do we look at the judicial delays in a fresh perspectives, especially when you look at how a few public interest litigations have evolved and been argued in the Karnataka High Court. Our analysis actually led us to some very interesting exploration. While for long there have been multiple attempts to have case flow management rules, we find that there is no streamlined implementation of these case flow management rules. And hence we propose new ways and methods in which the next hearing can be done for any case that is being heard. When we start regulating the next hearings and we start keeping in mind the impact of each hearing on the petitioner and those counsels who are representing the petitioners, we will probably evolve into better case flow management as compared to what we are doing today.
I would urge all of you to buy a copy of this volume. It has a lot of information on the impact of judicial deals. Thank you.